Have you ever wondered exactly what constitutes a lease under Louisiana law? Under Louisiana Civil Code Article 2668, a lease is a bilateral contract whereby one party, the lessor, binds themselves to give another, the lessee, the use and enjoyment of a thing for a term, in exchange for a rent. Under Louisiana law, a lease contract may be established either orally or in writing. However, specific considerations apply when dealing with immovable property. According to Civil Code Article 2681, while leases generally have flexibility in their form, a lease concerning immovable property must be recorded to be enforceable against third parties. This ensures protection for both lessors and lessees, particularly regarding third-party claims and property transfers. Recordation of leases affecting immovable property is governed by Revised Statute 9, Section 2742. This statute outlines key provisions for recording a notice of lease, providing critical information that makes the lease effective against third parties. Essential elements for the notice include identification of the leased property and parties involved, clear terms of the lease, including the commencement and termination dates, details regarding any options or rights of first refusal associated with the lease, information on subleases if applicable, and authorization for representatives empowered to certify lease facts or amendments. Moreover, amendments or changes affecting parties' rights under the lease must also be recorded. Specifically, a notice of amendment is mandatory upon a transfer of the lessor's or lessee's rights, or changes in authorized representatives. The effectiveness of recording is significant. Once a notice or amendment is recorded, it binds third parties from the date of recording until the termination date explicitly set forth in the notice. Additionally, Revised Statute 9, Section 2742 clarifies that the transfer of leased property does not automatically terminate the lease. Both lessor and lessee remain bound to the lease obligations unless explicitly agreed otherwise. Furthermore, if immovable property subject to an unrecorded lease is transferred without notification, the lessee may have recourse against the lessor for damages incurred. Understanding the form and recordation rules is essential for effectively managing leases, especially concerning immovable properties, safeguarding the interests of all involved parties. For a lease to be valid, several essential elements must be clearly defined. First is the thing. Clearly identifying the thing being leased is vital. It can be movable or immovable property. Second is the rent. Rent must be determinable and agreed upon by the parties. It is a critical component that distinguishes a lease from other types of contracts. And third is term. The duration of the lease, either fixed or indefinite, must be agreed upon. However, it is important to note that a lease may not extend beyond 99 years. All parties involved must have the legal capacity to contract. For instance, minors, interdicts, or persons deprived of reason may not validly enter into lease contracts without representation. Under Louisiana Civil Code Article 2670, parties have the freedom to enter a contract to lease at a future date, provided the object of the lease and rent are determined or determinable. Such a contract is enforceable by either party if there's mutual agreement on the property to be leased and the amount of rent, unless explicitly agreed otherwise. However, if there's an agreement that the lease would not be binding until put into writing or until other terms are settled, the contract remains unenforceable until these conditions are fulfilled. Leases in Louisiana are categorized based on the agreed use of the property as follows. First is a residential lease. This is property that is leased for dwelling purposes. Second is agricultural lease. This involves a pre-dial estate leased specifically for agricultural activities. Third is mineral lease. This is for property leased for mineral extraction or production. Fourth is commercial lease. This is when property is used for business or commercial activities. And finally is consumer lease. This is for movable property leased primarily for personal or family use outside the lessee's professional trade. This classification is not exhaustive. Other purposes may exist. When leased for multiple or mixed purposes, the primary or dominant purpose determines the character of the lease as per Civil Code Article 2671. Now it's important to cover some obligations of the lessor. This includes the following. The lessor is to deliver the property in a condition suitable for its intended use, maintain the property throughout the lease, and protect the lessee's peaceful possession against disturbances. The lessee is also subject to obligations, and those are as follows. The lessee is expected to use the leased thing responsibly and according to the contract, pay rent timely as agreed, and return the property in good condition at the end of the lease, except for normal wear and tear. Leases may terminate naturally at the end of the term or prematurely under conditions like mutual consent, breach by either party, or unforeseen circumstances rendering the property unusable. The lease creates enforceable rights and duties between lessor and lessee, and it can affect third parties, particularly when leases are recorded properly in public records for immovable property. When dealing with movable property, Louisiana provides distinct guidelines under the Louisiana Lease of Movables Act. Under this act, leases of movable property are regulated specifically and distinctly from immovable property leases. Movable property leases may also take the form of financed leases, a specific type of secured transaction that favors the lessor. Financed leases, formally recognized as conditional sales transactions, retain their classification as leases. However, they are uniquely subject to the Louisiana commercial laws, specifically Title IX of Book 3 of the Civil Code entitled Lease, as well as Chapter 9 concerning secured transactions. A true lease, distinct from financed leases or rental purchase arrangements, is defined under Louisiana law as a lease arrangement genuinely intended for the lessee's use and enjoyment, rather than for the eventual ownership of the leased property. Under the Lease of Movables Act, true leases are specifically distinguished from those arrangements intended as disguised sales. Certain leases, however, are excluded explicitly from the Louisiana Lease of Movables Act, and these include the following. Leases involving immovable property or incorporeal movables are not covered. Leases of movable property that become component parts of immovable property, except where the lessor retains ownership of the leased equipment even after immobilization. And leases involving incorporeal movables, such as licenses for computer software, trademarks, copyrights, or franchises. Understanding the specific categorization and rules governing leases of movables is crucial, especially regarding financed leases and true leases, each carrying different implications and obligations under Louisiana law. In short, leases under Louisiana law must clearly define the leased thing, rent, and term. Both lessors and lessees hold specific rights and responsibilities, ensuring clarity and legal enforceability. Special attention must be given to the capacity of parties, property maintenance, peaceful enjoyment, and proper termination. Now that you have a clearer understanding of leases, you're better equipped to manage and execute lease agreements confidently as a Louisiana notary. Be sure to like this video, subscribe, and hit the notification bell to stay updated on more insights from the fundamentals of Louisiana notarial law and practice. Have any questions or suggestions? Drop them in the comments below. I look forward to hearing from you. Thanks for watching and see you in the next video.